Jan Ozer here. I'm talking today with Gottfried Schüll, a partner at Cohausz Florack, who is representing three members of the VLA HEVC patent pool in a patent infringement suit against Microsoft in Germany. By way of background, the patent pool was formed by MPEG-LA in 2015 and acquired by VIA-LA when MPEG-LA and VIA merged in 2023. It currently has over 550 licensees, including Apple and Sony. Thanks for joining me, Gottfried.
Thank you, Jan. Thank you for welcoming me. It's a pleasure.
My pleasure. So which patent owners are you representing, and why doesn't VLA bring this suit directly?
So, we do not disclose the patent owners who bring the suit traditionally, and the reason why VLA is not suing, it's basically, I would say it's a strategic decision of VLA. The patents are still owned by the owners, as it says, and VLA has a right to sub-license according to the license agreement. And the decision is that the patent owners file the litigation cases.
Okay. Which Microsoft products are involved in this lawsuit?
Yeah, there are quite a lot of Microsoft products involved. First of all, it's Windows 11, which is coming with an HEVC compliant decoder. Xbox as well as the Surface tablets. A little bit different is the usage in the Windows 10 operating system, where you have to download a decoder and you have to pay for it. And these are the products. The payment, by the way, for the download would easily cover the license fees.
Okay. And what are you suing for? What can you tell me about the damages that you're hoping for or suing for in the lawsuit?
Yeah, that's something very different in Germany from cases in the United States. We don't sue for damages. So it's formally included. So it's not correct to say we don't sue for that, but that's not our goal. We are going for the injunction claim. So our goal is to obtain a cease and desist order by the court, which would stop the defendant in bringing the products on the market. And that's a key advantage of the German venue because that's taken very serious. So if the court order is not obeyed by the defendant, we have all kinds of punitive measures to make the defendant getting compliant with the court order. That's the key. That's the silver bullet under German patent litigation law.
Okay, is that why a company like VIA or the members of the pool would sue in Germany as opposed to the United States?
Yeah, I guess so. Perhaps it's worth in that context to mention that we have a long tradition in suing for the licensors of the programs managed by MPEG-LA and VIA-LA for more than 20 years now, nearly 25 years. We had about 500 patent cases in about 35 campaigns. So we are the hotspot for patent litigation here in Germany for these programs. My understanding is the reason is that the injunction claim is a very powerful claim in case you want to have a starting point for discussions.
Okay, and what would, facing the injunction like that, what would Microsoft have to do? Would they license in Germany? Would they license worldwide? Or typically, how do they get out of something like that if they see the facts going against them?
Yeah, that's typically a defense which is raised by the in historic cases by the defendants that they only want to take a license for Germany or now for the EU when you talk about the UPC, so the new European Court. But it's accepted jurisdiction in Germany that it's not sufficient. So the pool can insist on only settling the case based on a worldwide license.
Okay. And what can you tell us about the facts of the case? How long was VLA seeking a license from Microsoft? Do you have any history you can share?
Yeah, I have some basic history. The program has started in 2015, as you mentioned already, and the communication started in that year. So it's communication now for 10 years.
Okay. And what's been not to use a technical term, but what's been the holdup? Why hasn't Microsoft taken a license so far?
I guess that's a question you should better ask Microsoft. Yeah. Of course, we don't know. They are, at least I don't know. Yeah, I cannot tell you.
Okay. So looking at German courts and their treatment of patent pools, what's the sense of the value of patent pools in German courts?
Yeah, the German courts accept it very much. That is a very efficient tool of settling patent licensing cases. Also for the courts, you imagine if you have about 30 licensors and 500 licensees, if you would have interaction and court interactions in between them, that would be absolutely inefficient, and that's absolutely accepted by the court. And that has been a discussion already in the first case we filed in 2000. So that has been very clear from the beginning that the court is very fine with the idea of a patent pool, also in line with the guidelines of the European Commission.
Okay. And if these companies win in Germany, how much reciprocity is there in other courts in the EU and in the United States?
I guess by reciprocity you mean acceptance of other courts of the decisions of the German courts and vice versa. Yeah. So that's very difficult to judge. We always think about like that. The judges look at decisions, our judges look at decisions from other countries. We expect that other judges in other countries do the same, but they make up their own mind. So there's no clear binding. Having said that, at least in Europe, I can say that the decisions of the German courts in patent litigations are very respected all over Europe. But there's no binding effect of that.
Okay. I know there's been a slight trend, or maybe a major trend, in some of these patent litigation cases that when you have a very unwilling licensee, you can lose the FRAND defense and charge basically a reasonable fee that's not FRAND restricted. Is that something that you see in Germany?
Yeah, I believe what you're referring to is happening in other licensing programs. The licensing programs of MPEG-LA and VILA are somehow the gold standard of FRAND licensing. So that have been the first licensing programs where patent litigations have happened in Germany. And these things you're referring to do not happen in these cases, in our cases. Yeah, it's perhaps a different situation. I can explain it like that. Yeah.
Okay. So how many, MPEG-LA started approaching Microsoft in 2015. It's now 2025. How many years back can you go when you seek a judgment like this?
There's no limitation. The only point is that the patent has to be still in force. Yeah. So patents expire in 20 years after filing, and for the injunction claim, there's no limitation. So you can always, as long as the patent is in force, you can go for the injunction claim.
That's right, and you're not going for damages, so the historical damage amount wouldn't matter. Speaking about EU law, I know there's been a lot of proposed changes in the EU patent law over the last 12 months. What's happening, and what's the status of all that?
I'm not sure if I would call it changes in. Also, there has been a discussion about EU regulation about SEP patents licensing, but that has been withdrawn recently, very recently. There has been, of course, the introduction of the Unified Patent Court, which is 1.5 years ago, which has been established, and it's picking up pace and picking up cases. And there has been also one discussion. There has been introduced into German law an additional requirement regarding the injunction claim concerning proportionality. But that has not, all this has not changed the proceedings before the German national courts, and we are talking here about proceedings before the German national courts. I believe there's not really change, at least in our environment, no changes which affect the situation.
Okay. So looking at the case itself, I know you've done a lot of cases like this. What are the defenses that Microsoft is likely to propose against the plaintiffs in this case?
Yeah, these are typically, as in every patent litigation case, we have the defense that the patent is not implemented, not used. Defense number one. Defense number two is that the patent is invalid. These are irrespective of the type of patent. And then we have, in the field of standard essential patents, and we are talking here about standard essential patents, SEPs, we have the defense that the licensing program under which in our case, under which the SEPs are offered for license is not FRIEND, so it's not fair or reasonable and not non-discriminatory. That's the next defense. And the further defense is that the offer of a pool license is not in line with FRIEND, but a bilateral license offer has to be made by the plaintiffs, thereby evading the pool license. So these are the four defenses basically we see.
Okay, and
I'm speculating. Up to now, we have not received the defense of Microsoft, of course. So okay. That's what we expect.
I mean, the last defense seems counter to the whole benefit of the patent pool. I mean, you've got the pool now with over 550 licensees, and they've got 23 license owners or patent owners. I mean, that's over 10,000 individual licenses if they force a bilateral agreement. I mean, is the court typically going to listen to that?
They always listen. Yeah, but you're absolutely right. There's a factual evidence or factual binding to the situation which has been established over the time and resulted in that many license agreements. And the legal way to interpret it is that in a situation in which a pool is as established as HEVC pool we are discussing, there is no other way than taking the pool license, because bilateral license would be discriminatory because other licensees have a full license, and so the licensors cannot even grant bilateral licenses because then they would render the whole program unfriend. And there's only one way out of that under bilateral licenses, which is that the defendant is seeking bilateral licenses from all pool members, which does not make sense economically. So there's, as I said, the court will listen to that. The likelihood that will play an important role is, I would say, remote.
Okay, and the FRAND defense, I mean, with 550 licensees, I mean, that seems pretty remote as well.
Yeah. So the FRAND defense, also we have here a licensing managing entity which has established an image over the last 25 years for treating fair and transparent. The FRIEND defense is, of course, we have to cope with that always. But as you said, I estimate that also as remote. Yeah, that will be successful.
Okay. So when did you bring the suit, and what happens now, and how do you see it unfolding over the next few months or years?
So we are bringing a suit as soon as the licensors decide to bring a suit. So that's what we do. As soon as we have filed the cases, which is presently the status, we have brought the cases over the last months. They got served, and now there's a deadline for Microsoft to file their statement of defense, and then things will progress. Typically, we expect, nearly in all cases, a defense by filing a parallel invalidity action. You know, we have a bifurcated system, perhaps you know that already in Germany, so the validity is dealt with in a separate court. So it's not before the infringement court. So that is what happens in the next months. We expect the bringing of invalidity actions, and we expect a decision by the infringement court within the next about 12 months. So on the injunction claim. In the meantime, sorry.
Do you know if VLA or MPEG-LA has already defended that type of claim? I mean, have the patents been found valid by German courts in the past, or any courts that you're aware of?
What we did, we had a case against another unwilling licensee ending about 1.5 years ago, where we asserted parts of the patents we're now asserting, and they have been attacked by invalidity cases as usual, and but the case has been settled by taking a license by the defendant shortly before the main oral hearing. So it might be reasonable to conclude that that he was not that optimistic about the chances of success on validity. Yeah, that's the situation here. That's we are presently discussing about the second HEVC case, which has been brought.
Okay. And just out of curiosity, did they take a worldwide license with the pool?
Sure.
Okay.
Sure.
All right. So go ahead. We have the infringement, or we have the validity decision, and then what happens?
Yeah, we have the invalidity decision is typically after the infringement decision. So the infringement decision will be ruled without having the validity decision of the Federal Patent Court in Munich. That's at least in, I don't know, 99% of all cases. But the infringement court is also considering the arguments in the validity case and is making up its own mind. And if the infringement court, which is the judges in the infringement on the infringement benches are highly qualified, also technically qualified, and if they have considerable doubts about validity, they will stay the infringement case, irrespective of an outcome of the invalidity case. Yeah.
Okay. So looking at the timeline, how is this going to roll out? When would you expect a final resolution?
That's difficult to say. As I explained or mentioned, we had many campaigns, more than 35 campaigns over the last 25 years, and everything is possible. So we have seen campaigns settled immediately after filing the complaints. We have campaigns settled after the defendant has considered everything properly, I would guess so. Then we have cases settled typically just before the main oral hearing in the infringement case, and then later on as well.
I mean, if it goes through the courts and there's no settlement, how long, what's the maximum? Is that a 2-year process, a 1-year process, a 5-year process?
So, yeah, we know we have about 1 year until we get the injunction claim. And as soon as the injunction claim has been issued, the typical measure is to enforce the injunction claim, meaning stopping the defendant to sell its products. And as I said, there are a lot of punitive measures if he does not comply, to enforce that. And according to that, we have not had a case which lasted longer than, nearly not. We had one better, yeah, but that was a minor case, longer than 3 months after the injunction claim.
Okay.
So it's about 1.5 years, the latest, when typically cases get settled.
Okay. And do you have any experience in U.S. courts? I mean, how long would it take for a similar case in the U.S. to reach a conclusion? No,
we have no experience in U.S. courts. No, I cannot tell you. But only remotely. I'm not qualified to that, and I would say typically in the U.S. it is taking longer. But and you have a jury trial, which is, according to my understanding, much different from the German benches, which are staffed by judges which are basically doing nothing else than patent litigation cases. So it's much easier to explain something to them than to a jury, I guess, at least. So I've never explained anything to a jury. Yeah, so I believe our proceedings are pretty swift, and what I explained is also there are also courts which, it depends always on workload of the courts, which are faster. We can also have verdicts after 6 or 8 months.
Okay. And what's the typical response? Have you ever seen a product actually stop shipping in a company, or do they usually Does anybody ever just say, okay, we won't ship in Germany, or do they always take a license?
No, we have not seen anybody who's really seizing products in Germany. Everybody has taken a license, yeah, eventually, yeah.
Okay. Listen, thanks for the information. Those are all the questions I have, and I'll let you, it's Friday evening where you are, and I'll let you go.
Perfect, thank you. I'm happy that that I had the opportunity to ask your questions and gave you some insights in our German special patent litigation system.
Yeah, it was useful. Learned a lot. So thanks again.